do feel free to raise those questions on the chat box so that we can also follow up on regular reactions and interactions. Yeah. Thank you very much. I'll start with my presentation now. Can you see my screen?
Yes.
Are you able to see my presentation?
Yes, everything is fine.
Okay. So, so before I start, I would like to say that as a person who has worked in the industry for about 15 years in IP and about 20 years in other areas as well, one of the first things that I realize is that while domain specialists are very focused and pay more attention to their own particular domains, when it comes to industry, they are thinking more widely. So when a company wants to file a patent, they're not really thinking about only filing the patent. They're also thinking about standards. They're thinking about brand name. They're thinking about cost price, supply chain management, data management, and so on. So a company or an industry is more keen to understand what will be the business outcome of any invention or any innovation or development. So when it comes to academia, industry collaboration, one of the basic pitfalls is this, that the industry has a different expectation and the professors and researchers have a different outcome in mind. So there are about 3 different things that I'd like you to keep in mind while we discuss this. Some of these things I'm sure that experienced professors are there, they will already know, but just for an emphasis, I would like to invite you to keep these 3 things in mind. The first is that industry is looking for making money from whatever innovation or outcome that comes out. The second aspect of that is that it should also be something that is socially useful or relevant to the market. Otherwise, there's going to be no market. So if the product is going to be something very different from what the market is used to, or product is going to be very different from the standards that the market is used to, then there's going to be no outcome for the industry. The third part is that normally researchers are thinking about outcomes in about 3 years, because the PhD is 2 years or PhD is 3 years. Maximum, they may think of a 6-monthly report on what they have developed as an outcome or what outcome they have managed to bring out in towards the larger outcome of the research. But most industries are looking for very tight milestones. I have seen researchers sponsor agreements where they say 4 weeks we want to see this, 8 weeks we want to see this, 12 weeks we want to see this. Now industry works on a very tight schedule because every season they need to come out with a new product, even if it is not a extremely new and completely disruptive product. It must still be new, novel, inventive, interesting. And it also has to create a certain outcome for the industry. Now, some people are raising their hands. Are you able to see the screen? Is it okay? Yes?
Yes, madam. It's okay.
Yes.
Please continue.
Okay. So let me show you one example of an integrated product that has come out from a company called Festo. So I invite you to see this and then we will discuss about it. Yes. So
Yes.
let me ask you, from those of you who are available, probably I will switch on the chat mode so that you can tell me. Can you tell me, from seeing this short clip, what are the different intellectual properties you could immediately recognize? You can type on the chat box if that is easier. design, yes. So Mr. Yadavalli Sriraman is saying design. Yes, certainly there is design in it. And where are the design elements found? They are found in the color, they're found in the shape of the wings, they're found in the shape of the battery charger. So actually what stands in the shape of the flower is actually the battery charger. Technology, Mr. Venkatesh Yepuri is saying technology. Well, technology, yes, but what type of technology? Maybe if you could explain it a little. Instrumentation, yes. So Ms. Shahji Dete is saying instruments, yes. There are many instruments there. This actually is what is called bionics. I'm sure you're aware of it. So the particular fact about these butterflies that Festo is making is they are trying to create artificially intelligent and machine learning components. So actually each butterfly is a component. Now the most beautiful thing about this is they're all flying in random motion, but they don't crash into each other, they don't crash into the surroundings. And what other work can you do with it? You can check the weather with it, you can check temperature with it, the quality of air, pollution, all those things can be decided. In fact, Festo has lovely videos on bionic products, which I would invite you to watch. Controlling, yes, definitely. Programming is there, controlling is there. Therefore, there is copyright. Algorithms are there, mathematics is there. Therefore, all those come under copyrights, tables, and so on. Very good. Based on electronics, electrical and mechanical. So electrical and mechanical technology. Thank you. Those are patentable, depending on whether they are already available in the market or not. Process optimization, yes, process optimization is a very, very important part of intellectual property, but unfortunately, it can only be protected largely as a trade secret. So when you put the different components together, it comes in transfer of technology language or assignment language, it comes under the a collective noun of know why technology, as opposed to know how technology. This is know why. So process optimization comes under know why technology. Sensors, yes. So sensors are being used for various reasons. One, of course, you can see the sensors positioned in the arena or in the room, which are actually detecting where the butterflies are flying, but the butterflies themselves are also equipped with sensors. Type of material used on the wings of the bionic device. Yes, absolutely. So that is biotechnology, more about nylons and chemical technology, more about fibers. So those are also patentable, not necessarily only the chemical elements, but also the design elements have other patents built into this. So wonderful. I'm really happy that so many of us are on the same page with regard to this. So what I intended to demonstrate was that technology, when we look at these kind of companies, is not one area that they are looking at, but they are looking at a collaborative way of using different intellectual properties like patents, copyrights, designs, and also a lot of it has to do with scientific observation. So what we call abstract science. So unless there is a proper understanding of the biology of the butterfly, of the physics of how the wings are flapping in the butterfly in the natural world, it cannot be brought into the artificially intelligent world. In fact, currently with the COVID crisis, we are seeing this extreme correlation between abstract science, biological science, virology, microbiology, and so on, along with chemistry, pharmacology, immunology, and biotechnology, apart from what are the other mathematical and other virtual models that they are using. Probably they're using MATLAB, I don't know, but to create or synthesize biomolecules, they are using certain types of algorithms. So all that has to come together, and industry only considers that to be valuable. A standalone technology by itself without other surrounding intellectual property doesn't actually protect the industry or the company when they go into the market. It is very important for us to see it as a collaborative and a cohesive ecosystem. So from there, let's just go one by one into the different intellectual properties laws that are available in India. And from then on, I will take us through how we can collaborate or put it all together, integrate in the industry. Now, the first thing that I would like you to consider is that intellectual property has a very long lifespan. And depending on the type of intellectual property that you're deciding to protect, innovation with, it depends on how long you can protect it. For example, let me give you the example of copyrights. So in this case, in fact, I have this example almost in every patent or copyright discussion that I have, because it's so important to remember this. In fact, once I went on the ship called Sagar Nidhi, which is managed by the Ministry of Ocean Sciences, and it's an ocean research vessel. So this ocean research ship is very interesting. It doesn't have an anchor. It has a dynamic positioning propeller system below it, so that when you put it on the sea in a particular place, it will remain in that particular place because it is geopositioning. It will decide where to stay and it will stay there. There are many important and interesting things about this particular ship, which is built by a company called Fincantieri. But one of the most important things is that the material with which it is built, it does not, it can withstand both the really cold temperature of the Arctic climate as well as the tropical climate of Chennai, so that the scientists can go in the ship to our Antarctic ice station called Gangotri and then come back. So when you read about the Titanic, we read that the sheet metal tore because the temperature was very low, and it had become so brittle and fragile that when the ice touched it, it got torn. But here, this ship is, it will remain malleable and ductile even in cold climates. But one of the most important and exciting things about it was that there was nothing Indian on the ship. There was no, not even a chair or a fan or a nut or a bolt that was Indian. It was all either German or Italian. But on the bridge is like the place where the pilot pilots the ship, the place where the controller of the ship. There I saw some charts. Those charts are called electronic navigation charts, ENCs. And these charts, when you are coming in from open sea into the harbor, you need about 100 different charts. And these charts keep changing with season, with temperature, with ocean currents, with any kind of disturbance in the sea or on the land. And therefore, the pilot must know which particular chart to use at which particular, excuse me a minute. Hello? Hello? Yes. 1 minute. Giridhar? I'm sorry, I had a call. So based on these, based on the climatic conditions and the geographical conditions, it becomes important for the pilot to know which chart to use. Now, each of these charts was about 1,200 rupees. And I was quite surprised because they were of Chennai Harbour. I live in Chennai. So they were of Chennai Harbour. And I asked them, why is it so expensive? Why is it that an Indian ship should pay so much for every chart? And then I did some research and I found out that that's because the chart is protected with copyright of the UK Hydrographic Office or the United Kingdom Hydrographic Office. Why is it protected by copyright from the UK Hydrographic Office? Because it is there on your screen in the middle, the first chart of the peninsula of Tamil Nadu of India was protected in 1689, and from then on, from the 17th century onwards, it has always been copyrighted, and till date it is under the copyright of the United Kingdom, which means that even though we are politically and technically free of colonialism, we are not free of their colonial intellectual property conditions. In fact, if you see on the top right corner of your screen, you will see that it says that the Indian Hydrographic Office will use the charts, and these charts, if I may read that, it says the complete folio of the official Indian electronic navigation charts are distributed worldwide through Jepson Marine and the United Kingdom Hydrographic Office and the Norwegian Hydrographic Office. In fact, India is a part of what is called the North Indian Ocean Hydrographic Consortium, which is the entire area, the countries in the North Indian Ocean who are part of the regional security conditions. United Kingdom, it continues to be a part of it. So copyright is a very, very interesting and very long-living kind of intellectual property. The other intellectual property that is nearly immortal is trademarks. So you can have trademarks that have lasted for hundreds of years. only as long as you continue to pay the renewal fee, they remain alive. Now, often, in fact, maybe the historians and those who are in law may understand this better, or they may have been aware of it. But most people who are in science or technology, people who are in the invention area, so to speak, may not be aware of the fact that intellectual property criteria, the requirements for how the intellectual property officers should function, what are the necessities for filing a patent, what are the necessities or requirements for filing a copyright, what are the ways that a trademark can be protected, how do you search a database, how this database should be maintained, and the fees for these databases are all decided by international treaties. And these international treaties did not come into existence in the 20th century. They did not come into existence after 1900. They came into existence after 1800. So if you look at the different conventions that cover us, that is the Paris Convention, which covers patents, the Berne Convention, which covers copyrights, the Madrid Agreement, which covers our trademarks, the Hague Agreement, which covers our designs, and the IP clauses which are there in the Paris Convention Treaty are all made in the early 19th century, which means that they're all in the 1800s and early 1900s. This is a very important thing to remember because at that time we were not a free country. So we were not free in 1945 when we went and signed the IMF agreement, and we were not free when in 1946 we joined the World Bank, but we were treated as an independent party, and therefore we have been bound by all these treaties that we have signed when we were a colony. After we became independent, we took a relook at some of our laws. Some of our laws are still from that time, like the Indian Penal Code is from 1861, the Indian Evidence Act is from 1861. So many of our laws, like the Police Acts, are in the 1878, our Societies Registration Act. So many of our laws are actually from the colonial period, and they continue, but we did take a relook at our intellectual property laws, and therefore most of the current laws that we have that are operating in India today are from after we got independence. Nevertheless, if you want to file a patent in another country, whether it's in Europe or America or United Kingdom, you still have to go under either the Paris Convention or the Patent Cooperation Treaty or the Berne Convention, which are all signed in the early part of the 19th or the middle part of the 19th century. This is just by way of explanation more than of any value to you, but it's very important to understand that when we are talking about intellectual property, we are not talking about one country. In some sense, it is a harmonized global process. And if you want to really look at expanding your profile as an inventor or expanding your network with other institutions across the globe, then you have to be looking at this. In fact, I think Professor Dubey mentioned that I work with several other institutions like Symbiosis, VIT, IIT, and so on. So when we talk to them, one of the things we inform them is that if an invention is made in Stanford, and the same invention is made in IIT, and the same invention is made in VIT, and the same invention is made in Swarnandhra College, there is a difference in the value that you can get for that invention. If it is made in Stanford, you might be able to sell it for 500 million. If it is made in IIT, you might be able to sell it for 20 lakhs. If it is made in VIT, then it might be about 15 lakhs. I don't know what the exact value of the invention will be coming from your institutions. So even though it is the same quality of science, it is the same quality of researcher, it is the same quality of data or evidence, you might find a difference because it is based on a global economic model that we have to look at. Let's start first with trademarks. Trademarks are easy to understand, and then we can go into the more complicated intellectual property. Most of us, we don't think that trademarks are useful to us. Trust me, they are extremely useful to us. So many institutions are now getting trademarks for their institutions. Like there was a small conflict, not a conflict, but a little discussion between Vishveshwaraya Institute of Technology and Vellore Institute of Technology, because they're both VIT. So there are several such little things coming up because branding is becoming more and more important. Is branding important to a researcher? Very much so. It's not necessary that every researcher should go and get a trademark for themselves, but it's very important that when they are coining new words, particularly new terms for the products that they are coming up with, like remdesivir or any of these new molecules that are coming up, when you name them, then you have to be very careful that you will be able to protect their names. It's a bit like when you discover a new star in the field of astronomy, then you are allowed to name it. But when you're naming it, you still have to go back and look at a catalog to see if there is already a similar name in existence. Trademarks are like that. So the first part of trademarks that you need to remember is that you need to do a search, and a public search in trademark is available on our intellectual property website run by the trademark officer, that is the Department of Industry of India. And so there you go on there, you will find a link called public search for trademarks, and in that you can do your search. In order to do your search, you need to understand that all the products in the world are classified into services and goods. So all the goods are products that can be sold tangibly. This is from a disk to a computer to a cup or a bit of cloth or food can be sold as goods. On the other hand, all the other things which cannot be sold as goods can be sold as services. This include hospitality, advertising, consulting, legal services. Any other services that you provide will have to be provided as a service. So there are 45 classes in all, and all these are divided into goods and services. So before you search, you need to know which class your product will come under, and based on that, you have to name your product. So mostly computer science products come under class 9, scientific products come under class 5, and so on. Food products, processed food products will come under class 29. Some processed foods will come under class 30, and so on. So you need to know what classification your product is. If you see, oh, Amazon is a great name and Amazon is a delivery platform, it is an e-commerce platform, I'm going to start a new product called Amazon Furniture, you might not get it, even though it is a different class, because Amazon is a globally well-known name. So you have to be aware of that as well. Today, you cannot get a trademark on Unilever, even though you may be doing some other product which Unilever is not doing. In fact, coming up with brands is a very, very, very exciting task, and a lot of consultants work on that. For instance, the arrow below the word Amazon on Amazon actually indicates that they sell everything from A to Z. That is the relevance or significance of the arrow. And if you see the Unilever symbol, almost everything they sell is on that little in that little logo. So you have honey, you have clothes, you have water, you have different types of products, and all of them are supposed to be represented within the view of the Unilever. So the process is of filing most of the intellectual property applications is quite similar. My colleague Prashant is also, I think, has joined the process, has joined this seminar. So if there are any particular requirements with regard to filing, he will be able to help us. You can ask in the chat. In order to file an application, you have to fill out certain forms, and then you have to file it in the patent office, in the trademark office. The trademark office may raise some objections. It may say that the mark is already there, or it is not a nice mark, it's an obscene mark, we cannot grant it to you, and so on. And based on that, we have to make a response. In general, you can do it yourself, but if you are finding it complicated, you can always come to a lawyer to help you. You must remember that you must keep your renewals up to date, which means that as long as you keep paying your renewal fee, your trademark will be alive even for a few hundred years. I don't want to go into all this. These are the different reasons for objection, but if there are specific questions on that, I will be able to answer you. I will just explain a few things here on the images that are there on the screen. For instance, the word apple. When you say apple, you can name a computer apple, but you cannot name a basket of apples apple. So the product should not be defined by its own name. So I cannot make clothes brand of clothes or soap brand of soap. I have to give it some other name. But in that, the name that I give cannot be a name that is talking about quality. So I cannot say best soap. Best soap is not a good trademark, or first class soap is not a good trademark, or soft ice cream is not a good trademark. So you need to know what kind of trademark it is, but you must see that it is original, it is new, it is creative, and therefore the best kind of trademarks are marks which are fanciful, which are imaginary, like the word Kodak. So apparently the word Kodak is derived from the sound that the analog camera used to make when you press the trigger. So it goes Kodak, and that's how the word Kodak came. Or Xerox. Xerox comes from the word for dry, zero. So Xerox is a coined word. However, over a period of time, it has become so common that it has now become the secondary word for photocopying in India, and it's a very difficult thing for Xerox. In fact, they are now trying to say you can't call it Xerox, you have to call it photocopying. There are also many cases that we have had in which we have been able to sell good trademarks. One good example is Nexmo and Nexmo. So our client was called Nexmo, and there was another big company called Nexmo. And Nexmo, actually, when they entered into India, they said, we want to close you down. You are using our name unofficially, but we were able to convince them to buy the trademark. So actually, both sides were successful in this. Our client got a lot of money, and the other side was able to stop infringement of their trademark. So let me now stop sharing and see if there are any questions that I need to answer. Why is the requirement of trademark? I mean, what amount royalty payments one can get out of trademarks? This is from research in economics. I don't know, the person's name is not there. So yes, as in general, trademark royalty is determined on the basis of the sales price of the product, and it can be anywhere from 5% to 15%. So this means that if your product is selling at 100 rupees and your brand is really successful, then you can get 15 rupees out of every soap or product unit that you can sell. If your brand is less strong, then you might get 2 rupees or 3 rupees out of 100 rupees. So most of the time, royalty is decided on the basis of the number of pieces that are sold. It is the same with books. So I write books. And when I wrote my last book with LexisNexis, the royalty agreement between me and LexisNexis and currently with Thomson Reuters is that I will get 12.5% of every book that they sell. So most of the time royalty is decided on the basis of the value per unit. Our ISO accreditation of institutions and products come under IPR? No.
Excuse me,
ISO,
madam.
yes. Yes,
I
sir.
think questions we can take at the last.
Yes, sir. I will go. Okay, I will go back to the presentation.
Let the participants keep the questions in the chat box. At last, we will take.
That's a good idea, sir. I will do that then.
Okay, thank you.
So in the last few years, trademarks have become quite valuable. In fact, some of the most valuable brands are listed here for you. HDFC and LIC and Tata Consultancy are some of the top brands. And some of the companies which make the largest amount of money and send it back, one of the big country companies is Suzuki. So they sent back a lot of money to Japan because of the brand Suzuki. So as long as we use the brand Suzuki and we use their technology, a lot of the money goes to Suzuki every time we buy a car. Now, this is very important, and I will come to that in a bit. But let's also understand that Indian companies have also understood the need to consolidate their trademarks. So you will see that in around 2006, Tata Brand Equity and Business Promotion Agreement was signed between Tata and their other groups like Tata Motors, Tata Paints, maybe Tata Hospitality, and so on. And they all decided that whenever they use the word Tata, they will be paying a royalty to Tata and Sons, who is the promoter group. Similarly, Murugappa Group and Wadia Group also took it over. So now, today, As far as trademarks is concerned, it is a growing market. It's a very valuable market. And anyone who ignores trademarks and says they are not relevant to me may be actually losing out quite a bit of value. Let us now go to copyright. Copyright is essential in two ways to persons who are in academia. One is because they would like to publish their papers, which is a copyright issue. And the second is because they might be working in algorithms, or they might be working in software, or any of the areas where you cannot protect it in any other way. So you can't protect it as a patent, you can't protect it as a design, then you might consider copyright. So copyrights have two distinct uses in academia. Let me first quickly explain how you get a copyright. Getting a copyright is fairly easy in India. It also requires filing an application along with the fees, and then there is a possibility of objection. The objection will mostly come in asking, is it original? Are you the original author? If you're able to show that you are the original author and that it is an original piece of work, you will get a copyright. And normally you get a copyright in about 6 to 8 months, unless there is a opposition or a big objection. If you want to file a copyright in some other countries, you might have to take steps specially. But other than that, the Berne Convention, the treaties that we discussed, the Berne Convention covers copyright. So in the Berne Convention, it says that if you file a copyright in any country which is a part of the Berne Union, so Berne Union consists of 167 countries, maybe it's 1 or 2 countries more now, but if you file a copyright application in any one of these countries, then all these other countries will protect it, which means that if your copyright is protected in India, you are more or less protected in all 167 other countries. Therefore, it is much cheaper than some of the other intellectual properties to protect in other countries. Copyright copyrights protect original literary, dramatic, musical, artistic works, and also films and records. Since software is considered to be an original literary work because it is written down in paper or typed on a computer in India, it is considered to be a subject matter of copyright. In the US, there is a bigger battle between whether it's copyright or patents, because the original software was in the form of a punch card, and the punch card was a tangible outcome. Therefore, they tried to say that it's patentable. Whereas in India, by the time we started becoming proficient in software, it was already being written on a sheet of paper or on computer. Therefore, in India, copyright covers software. Embedded software products which come embedded with copyrights, they may be treated as patents, but for now let us stick to software as a copyright. Other dramatic, musical, and artistic works also come under copyright, and so do your journal articles and books and so on. Even the performances like what I'm doing right now. So as I'm speaking, there is copyright on the slides which I'm presenting. There is also copyright in how I'm speaking, what I'm speaking, and so on. So when you are recording, and that is one reason why the organizer has to ask the performer, can we take a record? Is it okay if we can put it on YouTube? So without my permission, it cannot be done. So original performances and records are also copyrightable. And as an advice, I would say that it's always good if you think that there is a very valuable piece of article or journal writing or research that you have done, to seek a copyright on it independently before you publish it in a journal. The journal generally will ask you to assign all copyrights to them, and sometimes they will file the copyright on your behalf, in which case they may even prevent you from utilizing your own copyright for future research. This means that if I have my own website, I will not be able to put my own article on my website. I will have to direct people. My article is available in JSTOR, my article is available in Sage, or whatever different platform is available. Therefore, it may be a good idea if you're doing really important work, if you're doing really interesting research, to also get your own copyright. It is also necessary for me to say that even if you put at the bottom of the page, the C inside the circle with your name and the year, that will operate as a copyright unless there is going to be a conflict. So if there are going to be 2 or 3 inventors working together, then you should come into an agreement whether the copyright will be filed by all 3 of you or by only one of you or by the institution or by the department. It's always good to do that because at the time of commercialization, these issues will will come in the way of successful commercialization or monetization of the technology. We have heard of many cases and we're also working with several of these cases, and most often copyright cases you will see in the context of films and advertising, but that is only because Indian creativity in copyright is limited to these areas. In other countries where they're doing copyright works, what do you say, extensive copyright work in software and so on, you will find a lot of other conflicts as well. One of the issues that I would like to talk about in this context is copyright in open source. So many of us, those who are working in the software field, might think that if it is free or open source software, then there is no copyright. No, that is not the case. Even in free and open source software, there is copyright. The only condition is that there is a license that flows along with the open source technology or software that you are downloading and using. And in those conditions, they will mention that whenever you're using a component of or a piece of my code, you please refer saying that this code comes from this person, has been downloaded from this website and so on. Whenever you include open source technology in your code or open source codes in your code, then you have to also release your code into the open source. It is not possible. In fact, why I'm mentioning this particularly is because we have faced several of these conditions, several of these conflicts where companies freely use open source technology and then they try to patent it. Often the licenses that cover those open source technologies will say that patenting is not permissible. So there are special licenses to do that and we have to discuss that. But my suggestion is when you download open source SDKs, software development kits, or any software code from online that says it is either copyleft or open source, then be clear what the licensing conditions are. If your technology goes to some other country, then you might have a big conflict on your hand. There are some interesting concepts on intellectual property or in copyright that can be discussed. Maybe if you raise these questions, we can discuss it. But I will just go through some 2 or 3 of them. The first is the sweat of the pro and originality. I have seen people trying to copyright products or copyright literary outcomes by collating from different places and putting it together, like a telephone directory or some other process like a library or a catalog. And they will say that it's original, it's not original. So putting together from different areas, it may be an original format, it may be an original design, or it may be in a different type of book or format, but it's not a new product. It is not original. So getting different things from somewhere and putting it together like a catalog is not copyrightable. Idea expression dichotomy. I write a software in a different language, you write a software in a different language, you can still get a copyright on that. So ideas are not copyrightable. It may be the same idea. So my software may also do the same thing. Your software may also do the same thing. The idea is the same, but your writing or the way you write is different. The way I write is different. My language is different. Both of us can get copyright. Fair use. So when you are writing an academic paper, then you have fair use clauses, which means that up to 5% of an academic paper you can use to cite, to say that I have taken this, to acknowledge, to cite, to critique, to criticize, to compare. So only about 5% in a literary paper. More than that, if you take, then it amounts to plagiarism. Parody and satire, you can also take it to make fun of people or to explain a point in a more interesting way. In fact, Tamil Nadu, we are becoming very famous for doing memes. So at the bottom of your screen, you can see a meme which became very popular during our Jallikattu protest. So it's a movie which is copyrighted. So they have taken a little clip from the movie, and then they have put faces of people who are recognizable. Again, some of these faces are copyrighted, or there is a privacy rule attached to them. You cannot use their faces, but because these are meant for political satire or political parody, or for create or commenting on a political situation, therefore it still comes under fair use. But please don't overdo it. My advice to the students in particular is don't overdo it. Also, check out whether the celebrity whom you are parodying is a person who is open-minded. Otherwise, you might have a case in your hands which you don't want. In order to just explain the publishing issues that we were discussing earlier, my advice to you is read the publishing agreement very, very carefully. Most of these terms and conditions are available on the publisher's website. You will find that some of them are very stringent. For instance, I know Emerald Publishing is very stringent. I know Sage is stringent. JSTOR is stringent, but ResearchGate is not so stringent. So it depends. NCBI is not so stringent. So please look at the conditions and terms of your publication. Make sure that you understand, and if you don't understand, please ask them to explain it. Generally, they're quite polite and kind in explaining what exactly they mean. If you still don't understand, ask a lawyer to explain it. Also ensure that when you are sending them the mail, you are informing them that it is your copyright, it's your original work. Generally, the larger publishers don't try to cheat you out of royalty. This is my experience. But I can't say the same about some local publishing companies and so on. So be careful who your publisher is. And finally, please ask your publisher if they are publishing your book, whether they will also split it into chapters. So you can actually go online and check. You may be able to buy a chapter of a book. The entire book will be $12, but then you can buy two chapters for $4. So if you don't want that to happen to your book, then you have to make it clear to the publisher that you can't split your book or tear it apart and sell it in smaller versions. The publisher is only worried about how much money he's going to make out of it. Coming to designs. So designs are, in India, design registration is granted for only how a product looks, or when you see it, only for the information that is received by your eyes about the product, which means that if it looks, so you can get a design registration for the shape of the cup, you can get a design registration for what is affixed to the cup, and if there is any other particular texture to it, you can get a design registration on it. But you cannot get a design registration on the functionality. In fact, there is an additional intellectual property available in some countries like Australia. These are called innovation patents, or in China, they're called petty patents or small patents. Now, this is between design and patent. So they are for how they look, but also for how they act, or what their functional outcome is. Now, we don't have it in India. So in fact, I did write a paper for the CII, and we did try to take it to the parliament and so on, saying that it is very important for Indians to have an innovation patent. We do a lot of jugaad. Jugaad is not patenting. Jugaad doesn't have protection under patenting, but jugaad in certain cases can be protected as an innovation patent because it is valuable. It has an outcome for that particular small industry or domain. It has a little bit of design element in it, and it has a little bit of functional element in it. It may not be fully original, and it may not be a new advancement, or it may not be disruptive, but it's still a small innovation. And if we started giving some protection to jugaad, some protection to innovation, a lot of our SMEs can benefit. So if you have a discussion on innovation sometime, we can discuss how to take it to the parliament as well. The process is about the same. By now, you would have got used to seeing this flow diagram. Most of these flow diagrams are the same. You have to file an application along with a fee. There is an examination, and then there is an examination report, and the report will tell us whether they are accepting the design or there are some objections. Normally, the objection will be that it is not clear, it is not original. One of the requirements for filing designs is that you have to file the design from all 6 sides, front and back, 2 sides, up and down. So without 6 clear views of your design, you cannot get a design registration done. What happens if it is a cube? Let us say that we are trying to protect the design of a black cube, which is the same. Any side you see, you still have to provide 6 sides. And I'm telling you this because it has happened that our clients have said, ma'am, it looks the same from any side, right? That doesn't matter. We need 6 views to protect the design. Here are some examples of designs. If you, as you are seeing, there may be some functional relevance to it, but then the design office is not concerned about that. For instance, if you see the 2 bottles on the left side of your screen, one bottle has a smooth lower end, the other has a slightly ridged lower end. The ridged lower end might give you better grip, but that doesn't matter to the design registry. As far as they are concerned, they will see this and they will say that this is different from this design. Again, see, since it is a bottle, from all 4 sides, it's going to look the same. It's not going to look different from one, but you still have to provide 4 sides up and down. And then you see the design registration, the car design being made here, the clay model being designed here. It's very important to understand that when you're designing big products, particularly families of products, you may actually have to have certain elements that go through the family. How do you know that a Hyundai car is coming from the Hyundai company? How do you know a Maruti car is coming from a Maruti company? This is because there are elements of design, and in particular in Hyundai, since I think 2011, they have been increasingly innovating on the fluidic design. So you're able to make out from the body that this is a Hyundai car. So along with the family elements, you still have to have a originality to get a new design. And then at the bottom, you see VDM. VDM is a kitchen products company, so household products company. So if you see here, the reason why I'm putting that little knob there is because VDM has designs. So we file designs for VDM for the whole stove, for the hob of the stove, for the frame of the stove, for the legs of the stove, and also for the knobs of the stove. So you can have many elements that are design protected in the same product. So you can have the entire product and then little elements that are also protectable as designs. It's not necessary just to have one big design. To the right bottom of your screen, you have one more company which came up with an innovation design, which is a heart-shaped idli plate. So one of the first questions that we asked ourselves was, do we want to protect the shape of the idli, or do we want to protect the shape of the mold? I leave you that question. Maybe you can answer it in chat and we can discuss it later. This I have put here the design registrations of Apple and Samsung, and you can see here how many views they have provided for each different design. So you see here figure 2, 3, 4, 5, 6. Anywhere you see, you will find these 6 sides, and it's without these 6 sides, no country will accept a design registration. Now, if you understand, if you can see and maybe make out, there are no dimensions to these designs. So unlike an engineering drawing, unlike an industrial design optimization drawing, there is no size or there are no angles. So it doesn't say 3 mm by 6 mm. No, it doesn't say that. That is not relevant for design registration. For design registration, it is only the size and shape of it that you have to see. Again, if I point out to you that there was quite a large number of cases that were fought between Apple and Samsung all over the world. One of the best or most interesting cases for us was decided in the UK by one Justice Burse, who actually very clearly differentiated the design between Apple and Samsung. In fact, he pointed out that the Apple design, there is a small start button in the front, whereas Samsung doesn't have that. Apple has a flat back after a bevel edge, a little curve and then a flat back, whereas Samsung has a slightly longer curve and it has a kind of a shallow shallow back. And then you see in the Apple screen, you have a frame, whereas the Samsung, the frame is very small, or in some cases in Samsung, there is no frame. So there are different elements. So when you are looking at design originality, they will go into all of these tiny things. And it's not about how the design functions, but how each of these elements are clearly described in the application. So when you're making a new product, please understand, it may look very similar to an existing product, but as long as you're able to make out these very tiny changes and very unique changes, you might be still able to protect your design. Um, for the industry, though, design is also an emotional effect. One reason why we buy products, why do we choose Apple over Samsung? Of course, Apple is more prestigious to own. Maybe it looks better, has better branding. And if your father is buying it instead of you, then you will prefer an Apple. If you're buying it yourself, you might prefer even an Oppo or a Vivo. But that's a different point. On the However, industry is very clear that design is not just about how it looks. Design is also about how it feels, how you relate to it, how I emotionally connect with the design, and so on. So designers are not just making it for the best shape, the most efficient shape. No, designers are also concerned about what is the emotional connection that I have with the product. So just to explain that a little, let me take you to the story of Swarovski. Swarovski, those who have interest in jewelry and design will know about Swarovski. Swarovski is a brand of crystals. Crystal is nothing but lead embedded glass. It was in 1895 that Daniel Swarovski decided to provide cut glass for jewelry. Before that, it was used for making glasses for drinking and for tableware and cutlery. Some crystals were also used as stained glass, like when they made stained glass for churches or big castles, they used crystal because it was strong and because it had it dispersed light very well. So it was only in 1895 that Daniel Swarovski decided that you can also make jewelry out of it. And it was perfect because women were starting to go out to work and they didn't want to wait for some man to buy them diamonds anymore. So they could buy their own jewelry, which looked as good as diamond and made them feel as good. But leaving aside the jewelry part, leaving aside the beauty part, let's go into actually the science of crystals and how Swarovski manages it. In 2007, Swarovski formed a partnership with Philips, which was the lighting giant. So in fact, today, if you go into any five-star hotel which has a big chandelier, I bet you that it will be a collaboration between Swarovski and Philips. And the reason that they're able to do it is because of a design that they have created called the Zillion cut, how they can, the shininess of a diamond or crystal, the burst of light that comes out of a crystal or diamond depends on how many faces you can cut on it. So they actually created one with more than 24 faces, and that's what gives them the edge in chandeliers. But and they went on to make a lot of other products as well. So once they knew how to cut glass, the technology of cutting glass, once they had made the machinery to cut glass, they knew that they can cut any type of glass, and they became the world leaders and continue to be world leaders in hunting scopes and scopes for sniper rifles. So even today, the best hunting scopes have Swarovski lenses. In 1892, Swarovski patented an electric cutting machine. So from one to the other, how integration of intellectual property is happening. There you have jewelry, which may be design registration, and then you have the cutting, which is again design registration, and then tying up and collaborating with the electronics giant. So that is more instrumentation, electronics, and electrical engineering. And then the cutting of glass, which is actually early in the 20th century, which is again lenses and glass, which is both physics and technology. And then we come to cutting machines. So in 1892, they created a brand called Tyrolit, which is cutting machines for cutting glass and crystal, which actually help them to create various other products. So in fact, if you go into any of the big highways, tunnels that we are having even today, I mean, even in India, if you go to the say the NH national highways, you will find cat's eyes or reflectors which are there on the roads. They are made by Swarflex, which is the same company that makes Swarovski crystals. So from high-end luxury to to commodity products you can make, as long as you're able to integrate all the elements of IP, and as long as you're able to see their different applications for different industries. So I like this quote, and that's why I put it there: constantly improve on what is good. So often we hear the American version of it, which is that if it's not broken, don't fix it. But here, Daniel Swarovski says, if you're doing something good, then keep improving it and making it better. Finally, we come to patents. Patents are an important aspect for most of us. We either have to use patents for doing our work, or we are working towards patents. Again, the process, as you are seeing in the flow, is about the same. You file an application along with the particular fee and then all the required forms, and then there is a examination. And in the examination, the examiner will tell you if there are any objections. They may say that your patent does not have the requirements to file to grant a patent. You get a hearing opportunity. You can do it yourself, or you can go through a patent attorney. And then after the examiner is convinced that your patent can be granted, your patent is granted for a period of 20 years. In these 20 years, you are allowed to make as many of the products as possible. You can license it, sell it, assign it. You can break it into bits and give it to different people so that different people can take it to different countries or to different markets. And at the end of 20 years, your patent lapses. So anyone who is in the market can start using your patents. What are the requirements for filing patents? In India, the patent barrier is higher than in America. So in India, the necessary steps for filing patents are that you must demonstrate novelty. Novelty means that the product is not there in the market. It's not there in any patent database. It is not there in any journal, patent journal, or any other journal. So it is completely new, and it's not part of traditional knowledge. It is not being used by some community in some other part of the world. No, it's completely new. Nobody has ever seen it before. Then that is novelty. Then comes industrial applicability. In India, the patent should be one that you can either use in an industry, or you have to mass produce it in an industry. So the question I often ask is, what do you do if it is something that has to be handcrafted? Suppose it is something that I have to make by hand. It cannot be made in machines. Can we still get a patent? We don't know. Such a question has not come up. For instance, Swiss watches. The Swiss watches are made by hand. Each piece is cut and made by hand. Maybe the components come from different places, but the end of the process, putting it together, filing it, ensuring that it comes together is done by hand. So they don't claim that it has industrial applicability. It has to be made as a handicraft. We'll discuss it a little later. But suppose we came up with a technology like that, then can we get a patent? I'm not so sure. I don't know what the situation will be. Some judge will have to make a decision on that. It has to have an inventive step. What is an inventive step? We have to separate novelty from inventive step. Novelty is something that is new. Inventive step is a new technology. New technology which changes the existing state of the art. So today, technology is here. Today, this is the standard of the technology. By filing this patent, I have raised the technology from here to here. How do we do that? By various integrative processes. We may change the material, we may change the product, we may change the design, we may change the measurements, we may optimize it. It could be different ways of doing it, but whatever it is, the technology level has to move from level A to level A plus, or level B, or level X. Unless that happens, you cannot get a patent. So pushing it to that level requires a lot of research. And then finally, there is a requirement for it to be patentable subject matter. These two are the list of non-patentable subjects are found in section 3 and 4 of the Patents Act. These include, very importantly, they include atomic energy. So that means you cannot get a patent on atomic energy in India. It will be, if you find something in atomic energy, you have to give it to either DARC or whichever department, DRDO, whichever department wants that product. You will have to assign it to the government. Will the government pay for it? Yes, most probably they will. So you cannot protect it in your name or in your company's name. You cannot get a patent on cloning of human beings. We can clone animals to some extent. We can clone plants, but we can't clone animals, larger mammals, and we cannot clone in particular human beings. So that also comes under that. Section 3 has a longer list. It says that for your industry, what may be important is that mere putting together of various elements. So there is an example here to the right of you, which is a setup for pulling up babies that fall into bore wells. So if you see here, it is just a connection of various products, various components which are already known, which are already there in the market, which are already available in journals and so on. Therefore, therefore, just by putting these different components together, you can't get a patent. You have to, after you put everything together, you have to show inventive step, you have to show novelty. Merely putting together, you will not get a patent. Also, you will not get a patent by just fixing a sensor or just by automating it. Suppose this thing is a manual device and then you now say, okay, I'm not going to do it myself. I will put a machine to do it, and now it's doing it by machine. You still cannot get a patent. So it has to show an inventive step. It has to be something new. I was recently interested in looking at a product which has come out, which is interesting. So you may have heard of this musician called Björk. She's an Icelandic musician, and she was quite famous, I think, in the 1990s. I know that during the MTV era and European charts era and so on, she was quite famous. She worked with Microsoft, which had come up with an artificially intelligent platform, and together they have made a music called Corsaf. Is that I don't know how to pronounce it, but I can share the link with you. So they have come together to create lobby music. Now, how it works is she provides her music, her vocals, her compositions to the AI. The AI takes input from the sky, from the weather, from the way the birds fly, from the way the wind blows, from the way different things happen in the environment, and then it learns and it connects with the music which has already been given to it, and then it creates new music. So every day there is new music. Every day, every time the season changes, there is new music. Every time during dawn and twilight, there is new music. When it's dark, it's new music. When it rains, it's new music. You cannot expect the same music to come up. And then apparently the system is learning. So it's becoming actually more proficient and coming out with more different variations of the original music that was provided by Björk. So the question is, who gets the patent or who gets the copyright? And who gets the who can protect the system as a whole? So it's an interesting question, and it's always there when we are working with artificial intelligence and machine learning capabilities. Suppose the device learns a lot more and then creates its own music, then who gets the copyright over that music? Can an artificially intelligent entity be given copyright, or will it have to be given to the programmer? Again, a question for you to discuss in chat and maybe later on. So I'm just suggesting these things so that you can think in more different ways and come out with different ideas as you go forward. I have a small interactive module, but we can look at that a little further when we go. Let's just finish this for now. So geographical indications is probably the last part of our intellectual property. Maybe I have something else on semiconductor devices, but this is the more important aspect. Again, the flow chart is there. By now you're familiar with it. Geographical indications are like brand name. They are like trademark, but they are not given to an individual, and they are not a fanciful name. They are relatable to a place. So you have Agra Peda, or you have Chennapatna toys, or you have Kanchipuram saris. So Kanchipuram, when you put it as Kanchipuram saris, the Kanchipuram operates as a brand. So you cannot give it to any one person or one company, but you give it to the entire community that is making the sari. If you're giving Chennapatna toys, then all the people who are toy makers, who are making toys, who are participating in the process of developing that industry will, as a cooperative society, get an indication. So this process is very new. Only in 2000, we got the Geographical Indications Act. But earlier on, in the US, in Europe, geographical indications have been very important for some time, mainly because of their liquor, cheese, and chocolate industry. Mainly because of their liquor industry. So the liquor industry depends on these local names, like Scotch comes from Scotland, Champagne comes from the area, region of Champagne in France, and so on. So they were very, or cheese, when you say mozzarella cheese, it comes from a particular region in Italy, and therefore that cheese alone can be called mozzarella cheese, even though similar cheese is made in Nasik with the same texture, same taste, same kind of feeling when you eat and so on. Nasik cheese cannot be called mozzarella, so that's why they have Nasik goat cheese as an independent geographical indication. So geographical indication has to align with the geographical regions, not by country. So you will find that Champagne region actually also covers a little bit of Switzerland. So it does not mean that it is bounded by national boundaries. It is bounded by latitudes and longitudes, and they are indicated by the area on the globe rather than on a political map. So here are some examples. You have cheese, you have brie cheese here, Darjeeling tea, and there you have Swiss watches. In general, in India, whenever we talk about geographical indication, we think of it as a kind of handicraft industry or a farming industry or a rural cottage industry. It is not necessarily so. And Swiss watches prove that, Belgian chocolates prove that. It is not necessary. For instance, Belgian chocolate, no chocolate plant can be grown in Belgium. Chocolate and cocoa plants all come from Africa or Brazil. But the chocolate is made in Belgium in a highly specified and very, very high-tech industry. So it is not necessary the geographical indication should be low-tech, handloom, rural, cottage, any of that. It can be a highly specific high-tech industry like Belgian glass or Swiss watches or Swiss chocolates. Some of the countries in the world have taken on geographical indications really well. We have lost out a little bit. I think our most expensive tea was sold last year for about 11,000 rupees per gram. This was found in the top reaches of Manipur, but there are other countries who have made better use of geographical indications. And I like tea, so I would like to see all of these, but it's very difficult because, as you see, some of them are extremely expensive. For instance, the last one there, Da Hong Pao, which is not even found for sale, and it's kept in very small quantities. The price tag for 1 kilogram is $1.2 million. So there are people who still buy this, and there is a lot of value in geographical indications. And I look forward to greater encouragement for the geographical indications intellectual property in India. This was one of the first cases in geographical indications that we argued. It has to do with a particular ring which is used in Vedic rituals in a place called Payanur in Kerala. Maybe we can discuss it going forward. There are some conflicts between geographical indication and trademark. So trademarks are brand names which are given to companies, which are given to people. Geographical indications are given to communities. You cannot have a conflict between a community and a company. There is also a different act for plants to protect new varieties of plants called the Plant Varieties and Farmers' Rights Act, PVPFR Act. There are some debates between these as well. For instance, if you have basmati is a geographically indicated rice. Suppose you come up with a new variety of rice, which only grows in, say, Narsapur in Andhra Pradesh or in one small area. Will it be protected as a plant variety, or will it be protected as a geographical indication? My thought on this is you can protect it as both. You can protect it as a plant variety for the purpose of the plant itself, and how you ensure that the seeds don't go out, they are not shared, and so on. But for the output, you can still get a geographical indication on it. Similar to, let me give you an example. If you have silk, you can get a trademark, you can get a patent or a particular law or a trade secret on the particular silk worm that you have created by various generations of reproduction. So that is different from the silk mark that you will get. So you can still get Kanchipuram sari mark as a geographical indication, although the silk worm that develops the silk is found in, say, Korea or Japan. Traditional knowledge and geographical indications are also closely related. Many, at least in India, many of the traditional knowledge products can be protected as geographical indication. There is also community knowledge. So there are some tribal communities maybe living in very remote areas who have technical knowledge of a very specific kind. Can you protect it as geographical indication? Depends. If the whole community lives only within that geographical area and that area is denoted by a geographical boundary, maybe you can still get a geographical indication on it. Uh, yeah, we can discuss this later. Finally, let me give you an example of how all of these things get integrated. So there was a client of ours who had come to us from Hyderabad, and they had come up with a coating, a special kind of coating on spectacle wear. The idea was that you could get different colors. So now sunglasses are available in 2 or 3 different shades. Through this coating, you can get many different kinds of shades, shades which we have not seen in sunglasses. You can also ensure that the glasses are scratch proof. So nowadays we do have anti-reflective and scratch proof coating, but this coating is much stronger and it's integrated into the glass, so maybe the glass won't break so easily and so on. So they wanted us to reach out to a few companies. So we try to explain how the industry is integrated, not only in terms of intellectual property, but also globally in terms of what each part of the company does. So we explained it through the help of the example of Essilor. So Essilor is a company, we are all aware of it. Maybe we know the brand Essilor, or we know the brand Varilux. So we know that these products are there in the market, and if you are above the age of 40, definitely you will know at least bifocal lenses that come out from Essilor or Varilux. So when we checked out these brands and we explained the process, we decided to make a map of it, and I'm going to present that map to you. So let us say the product, this coating, is invented in India. How do you integrate it into the global supply chain of spectacle wear? The first thing that we need to understand is that it cannot be applied to any spectacle and it cannot be applied by anyone. If you do anything to the spectacles that you buy in the shop, then you're likely to ruin it. And moreover, it will spoil your focus. It may not give you the right outcome that you want. So there are two problems with that. One is a problem of standardization. The spectacles and eyewear are also medical products and medical devices. So in order to have a particular product in the market, you also need to standardize it as a medical product, and then quality standards are also required. So the first aspect of it is we need to find out which part of the world they are doing research on lenses. Research on lenses directly, how the lens reacts with the eyeball. That research is done in China, particularly in Shanghai. Shanghai University, where they research how each lens interacts with the eye, our eyeball, our eye nerves, and then how we interpret that based on our based on the molecules in the eyewear and so on. And then the next step is Japan. The Nikon Zeiss lab in Japan is where they do the largest amount of research in terms of how the glass of the lens interacts with the eye. So in fact, some of the best lenses, even though they may be sold by Varilux or sold by Essilor, will actually be made by Nikon or Zeiss. Nikon Zeiss is also the company that makes most of our good camera lenses. So if you're buying the big cameras, the professional cameras, most of the lenses are made by the Nikon Zeiss or by Nikon. So the first patent will have to be filed in China, because that is where the research will be happening on the lens and how it works. And then the next patent will have to be filed in Japan, where the lens will go for further testing and to see how that lens interacts with other lenses and how that compares with other lenses. Because a company like Essilor will say, unless the product is going to be good, I don't want to change my product line. Assuming that the product trials there are good and you get a good outcome, the next patent or next intellectual property list will have to be filed in one of the European countries, which are the home base of one of these companies. So in the home base, this product gets integrated into their global supply chain. That is where the company will decide, okay, this lens is good. I'm going to see if I can turn it into a spectacles that I would like to give to other parts of the world. From there, they may also, the European company will also take steps to design it and for mass manufacturing. The best designers in eyewear are in Italy or France, continue to be in Italy or France, even though there are other places where they are designing eyewear. And by designing eyewear, I'm not talking about designing the lens, but the entire eyewear, which can be the frame, which can be the nose pad, which can be other forms of wearing the spectacles and holding it in your face. From there, it goes for process optimization. It cannot be that you are creating an artwork every time you create spectacles. So you have to design it for mass production. And then the mass production sites of most of these companies are here. Lately, I hear that Essilor has opened a production site in Bangalore, but I don't know. But most of the largest companies have mass production sites in all of these different countries. From these mass production sites, they may actually go to the US or again to some country in the Europe for packaging, because the packaging, the most sophisticated packaging industry is there in the US. So most likely the packaging will be designed in the US. Thereafter, it will be mass produced. The package itself will be mass produced in perhaps China or in Brazil or somewhere. And then one of these mass producing sites, say Bangkok, they will manufacture the spectacles. They will get the packaging material from China or wherever they are getting it, and then they will pack it, assemble it as a product, and then it will come back to India as a finished product. So when we understand that not only is there integration of design, copyright. So what happens in China and Japan initially in the abstract science area, those are copyrights. So even though you own the patent on the coating, you own the patent on the lens, they will own the copyright to the studies that they are carrying out in Shanghai or in Tokyo. And then it goes on to become design in the design. Even though you own the patent to the coating and the lens, the design registration of the spectacle will be owned by the company which designs it either in Italy or in France. And then it goes for mass production. Maybe the mass production sites do something unique to it, then they own the copyright or design registration over that. The packaging company has its own trademark, copyright, and design over the packaging. So you see, there are integration of not just copyrights, patents, designs, geographical indications, abstract science, and so on, but there is also collaboration between various companies which are based in various parts of the world. Why should we go for designs only to Italy? Why should we go for eyewear testing only to Shanghai? I leave it to you to answer. Maybe we can discuss it further, but it's very, very sophisticated, and it's also very stable. So today, if you want to design something, even when they wanted to design Nano, they went to IDEO in Italy. Even though it is an Indian car, even though it is an Indian idea, even though it is an Indian person who has designed it or put together the process to design, it still gets designed in IDEO. There are 700 patents on the Nano car, and there are some 60 design registrations which IDEO has. So it's very, very exciting and interesting to look at the integrated use of IP, and I hope to give you a glimpse of it, and I hope I have done it. So now I'm going to stop sharing and ask if there are any questions. I will also ask Professor Dubey if he would like to moderate the discussion, because I think there are a large number of questions. Yes, sir.
Hello.
Yes, sir. Please.
Thank you, madam. It was very nice talk.
Thank you, sir.
And so informative.
Thank you, sir.
So, dear participants, now you may ask question. You can raise your hand also so that we can unmute you, or else you can keep your question in the chat box.
Yes, sir. There are some
research in economics. He's having one question.
Yes, sir. Sure.
Yeah, unmuted. Yeah, you can ask now.
Good evening. Can you able to hear me?
Yeah, good evening.
Good evening, sir.
Hello. Okay, I think he's having some problem.
So isn't it just better that we go on from the chat, sir?
Yeah,
That
please, please.
we will save
This
time
will be
and
fine. Yes.
yeah, yeah, unless there are specific questions that they have.
Yes, please.
Research in economics, please type in your question and I will answer your question as we go along. So shall we just start from the last question that I have? So, Mr. Venkatesh Epuri is asking, can you please explain the comparison between Indian patent and US patent? There is a large degree of harmonization between patent regimes in different countries. Even so, the level of inventive step required to get the US patent is called non-obviousness. So as long as the researchers in the domain consider that device to be the new, excuse me, as long as researchers in that area consider that innovation to be non-obvious, not obvious, something surprising, something exciting, you can get a patent in the US. In India, that is not sufficient. In India, it has to be a tangible development of the research over that. So like I told you, if the state of the art is here, India requires it to be an inventive step. The research, the technology has to take a big jump. Only when that jump is taken, you can get an Indian patent. But for America, it can be in the state of the art. This is the old technology. This is the new technology. Both are in the same zone. But as long as this is surprising and the researcher says, oh, wow, I didn't expect that catalyst to do that. Or he says, oh, that's exciting. I never thought of that. Or I tried it and I failed. How did you succeed? You can still get a patent in the US. That's the difference. Can you please explain, okay, that we have done. Does the value of a patent vary from place to place? Yes, it does. It varies on the basis of the brand of the institution that makes it and the brand of the person who makes it. That is why it's very important for us to have patents in companies and in larger numbers. And it's also important, for instance, the same technology coming from IBM and the same technology coming from Tata, there will be a difference in the value of the patent. For sure, it will be different because it is a market. At the end of the day, intellectual property market is a market. So just like you go and buy, say, vegetables from the shop or vegetables from the street, there is a difference in the cost. It is like that.
Good evening, ma'am. Can you able
Yes,
to
sir.
hear me?
Yes, sir. Yes, I'm able to hear you.
In India, we have patents for 20 years only, right?
Yes.
So, if the patent application, why they are giving the patents application? The time of patent is from the patent application date and not on the grant of patent.
Ah. Yes, sir. That's because they decided in 1861 that they will grant like that, sir.
Oh.
So the rule across the world is the same, that the life of the patent will be calculated from the date of the application. So in fact, if the application is granted faster, we get a longer time to be in the market. So if it is, let us say that in fact last year we got a patent grant in America in 9 months for a patent, and it is still pending in the Indian Patent Office. So if it is 9 months, it means I still have 19 years to market my products. But if it takes about 4 to 5 years, then it is only 15 years to be in the market. It is so, sir. It's a legal decision that has been taken.
Yeah, but it discourages the innovation. That is why the reason of.
It is a very, very big. You're absolutely right, sir. In fact, it is a very big difficulty for companies that work in electronics and computers, because by the time the patent is granted, the technology is already obsolete, right? So if you don't get the patent in about 6 months, in about 2 years, the technology is no longer valuable. You're absolutely right, sir. We have to. That is one reason probably why an innovation patent might be useful.
What about is there anything like global patent or international patent?
No, sir. There is no global patent. Every country offers their own patent regime, and every country only protects the patent in that country. But there is a World Intellectual Property Office. You can, through the patent cooperation treaty, there is a treaty between different countries. They have agreed to cooperate, that you can file a single application in the World Intellectual Property Office, and this will give you 30 months time to go to different countries. So this helps you to get partners, or helps you to get the funding or improve your budget, and then you can go to different countries. So it only expands the time that is given to you. So that's the only advantage, sir. Otherwise, you have to go to every country. And just as a very, very loose estimate, it will cost you about $5,000 per country. So it's a very good idea to start thinking about partnering with companies in other countries, or partnering with partners of in other countries before you go abroad, because otherwise it may become very expensive for you. Yes, sir.
Yeah, I think there is next question.
Would you help tell me how this will help UG students? Undergraduate students, you have to start. Okay, you if you are geniuses like Larry Page or Bill Gates or so on, you won't be asking this question. So since you are like all the rest of us, I would say take your time to go through some patents websites. Look at the Indian Patent Office website. Maybe Prashant can type it out here. Go through the Patent Office website, look at the different patents, and start following a process. In fact, one of the processes that we talked about is also available in my book, The Lab to Market Guide to Inventing. So you can invent good products, but you will have to follow a very strict process of research and development. And that's all the guidance that I can give you at this stage. GeoMeet imitated Zoom. Does it a copyright violation or not? So I'm not sure how GeoMeet could do that cut and paste job. And actually, I'm a little sad because with Geo's resources, I'm sure they could have found some designers to make a unique design. They should not have to have copied. But if you ask me, I might say that maybe they have entered into some sort of an agreement or partnership with Zoom. Maybe that is why Zoom has given them the design. Otherwise, it is also possible that Zoom will come after them now in the future, right? Source codes are not copyright protected. No, source codes are copyright protected. Idea is not protected as copyright. It depends. I don't know whether Zoom has used open source codes or they have used copyrighted codes. Maybe, I don't know. How to distinguish? Yeah, Zoom might very well have used proprietary code. I think Zoom would have used their own code. How do you distinguish information that can be sought by RTI and the sort of information that come under IPR? The word patent means open. The word patent means put out in the open. All patent documents are free to read. They are open in the market. You have to just go on patent, Google patents or free patents online, and you will file all the patents. All copyrights are also free to see. None of these things are closed. All designs are available in catalogs. So there is nothing that needs to be, you need to file an RTI to get. If it is filed as IPR, it is free and open. So you don't have to file an RTI. You might have to file an RTI if your application gets lost in the patent office. Then you might have to file an RTI saying what happened to my application. But if it is a granted application, it is there for you, free to see. Why is that we discussed. So include some information relating to economics. I think I did, but if there is any special question, I'm happy to answer. Type of material, yes, that's it. Any other questions, sir? I think we have reached the end of the questions. There are 12 messages at the bottom. Okay. Do IP works as a good tool for economic growth of India? That's a very good question, sir. In fact, right now, China is filing the largest amount of intellectual property, largest number of applications. In fact, when you look at the global databases, it's hilarious. You have world and you have China. So no longer is China even included in the world statistics, because if you put 1.5 million applications from China and you put 4,000 applications from India, it won't even show up on the graph. So they have decided to keep China separate and then publish the statistics of the world. So if you ask me, has China benefited? Yes, they have benefited immensely. But more important than filing applications is about how good the research is, how valuable the products are that are coming out from the research. So IPR is only as valuable or is valuable only when the products that it protects are really good. So unless we are able to say that this product is really valuable, there is no point in filing an empty patent. In fact, one of the problems I have with institutions is that they file patents for profile. I have filed 5 American patents. What happened to those American patents? Did you get those patents? Did they become converted to products? Did they make money for you? Did they add value to society? I think that is more important than getting a number of patents or IP registrations for you. Yes. Any other question that you have? Prashant is giving some links if you would like to see. Those are the databases for patents that are available for free of cost. But if you are professionally, let us say you have an incubation center, or if you are going to work with it professionally on a regular basis and you want to use it to improve the quality of output, you might have to get a subscribed database subset. Depending on your technology, those are pretty expensive. They cost anywhere from 6 lakhs to 12 lakhs per annum, and but they're really good. So they also give you an understanding of which companies are looking at your research, who are the people who have looked into your domain, how best you can improve your design outcomes, and so on. So it depends on your use of it.
Madam, I have a question.
Yes, sir.
Madam, in India, we have about comparatively 45,000 patents only are filed in yearly. Nearly 45,000.
Yes. Yes, sir. Yes, sir.
But China and other countries are filing a lot of lakhs of patents.
Yes, sir.
In that 245 patents, what about the non-resident patents? Because it contributes to 80% of the patents.
Yes, sir.
So what is India's position in patents? Whether India can lead the IPR, that is a big question.
So I'm very happy actually that somebody from economics is interested in IP. In fact, if you read Paul Romer's paper on IP, it's very interesting. So he talks about exogenous and endogenous models of innovation. Basically, he's saying that unless there is an environment that supports innovation, and unless the support that is provided is towards a particular strategic outcome, then by itself IP cannot lead to any outcome. So what he's talking about is that there should be an environment or ecosystem that benefits from what is coming out. So again, we come to the same part. In India, as you said, around 50% of our, maybe more, I think, of our good patents, the monetizable patents are filed by MNCs. So if you see companies like IBM and you know, other companies like Shell and so on, they are filing more patents in India than Indian researchers. So I think even though the system may support innovation, as long as Indians do not directly click on the creative aspect of it and the standardization aspect of it, it's not really going to be a great benefit to India. Because all of these patents, like what is being filed by IBM, Shell, Microsoft, and so on, for all of these, royalty will be charged by the parent company in America, and the Indian subsidiary or branch will be paying royalty. So at the end of the day, more money will go out of India because of the patents which they are filing. So it's very important to balance this. In China, on the other hand, out of the 1.5 million patents that they are filing, only 5% are filed by foreigners. Others are all filed by the Chinese people themselves. So we have to look at how that model is evolving.
Yeah, even India also we also filing patents in US. The study has been done recently.
Sorry?
In India,
yes, sir.
In India, we are patent from US patent office, not in Indian patent office because of the delay in patent.
A delay in grant of patents. I think they have increased the number of examiners by about 100 or 150 in the last couple of years, sir. So I'm hoping that the process will become more streamlined, and hopefully we will get faster grants. But yes, it is true. But it's not only the patent office, it is also the court system. So in India, if you file an infringement case, it will take 10 years for the case to be decided, and you will have to go right up to the Supreme Court, which is very expensive. On the other hand, in China, an infringement case gets settled in 6 months. In Dubai, gets settled in 2 to 3 months. So in some of the other countries, like in Europe and so on, it may go on for a set period, like 30 months. So within their patent law in America or in patent law in Europe, they have a set period by which an infringement case has to be decided. So in the US, in pharmaceutical legislation, they say within 30 months, the case should be decided. If the case is not decided in 30 months, then it is to the parties to do whatever they require to move forward. Whereas in India, we don't have any such law. This actually makes it a little tedious. So even if I have a great patent, if it takes me 20 lakhs to get the patent and then it takes me 50 lakhs to protect it, it doesn't make any sense. Then I will feel better. It's better that I license the technology and do it rather than spend the money on the research, protect it, and then again protected from infringement. This is the
Yeah.
situation.
Yes,
Yes.
yes.
Ma'am,
So please allow to others also ask
Yes, sir,
question.
please.
If you have any additional question, you can send me email and I will
Yes.
forward it to the madam and we'll get
That's
it
a
back.
great idea. Yes.
Yeah.
ma'am, what is the difference between provisional and non-provisional patents?
Yes, I was about to come to that. Yes. So a patent document consists of 5 different parts. It has an abstract. An abstract is a 150 to 200 word paragraph about that introduces the patent. Then there is a specification. The specification is a description of the invention along with the drawings. Then there is the third part is the drawings. You might have illustrations or you might not have illustrations. Then comes the claims. So if the claims are the legal part, if you have seen any real estate document, the last part is the second part is the background. In India, we also we do not have to provide prior art. We provide it in the form of background. So in the US, you have to provide prior art in terms of patents or journal articles. But in India, you can just say this is the background of the technology. So I was saying that if you turn to the last page, you see a schedule. The schedule actually tells you exactly what is the boundary of your property. Similarly, a patent document has claims. The claims actually tell you what is the boundary of your invention. A complete specification should include claims. A provisional application does not include claims. If you are filing a patent application for the first time, then you don't have to include claims. You can just file a description and then you have 12 months. In these 12 months, you can do your research, you can refine your technology before the expiry of the 12th month, which means on the last day of the 12th month, you have to file the claims. The claims are the actual legal boundaries of your application. So the first application which you filed is a provisional application. The second application that you file is a complete specification. In the complete specification, the claims are the most important part. Why do you have these two processes? It is just to help the inventor. So I may have a great idea and I may want to pitch it to my investor. So I go quickly and I file the application, but I still don't know what is the final contour, the final boundaries of my application. I don't know in what industry it is valuable. I don't know what the specific temperature is, heat is, or whatever that is. So I will quickly file a provisional. Then I have 12 months. In 12 months, I can build a prototype, I can test it out, I can do experimentation, I can do beta versions, I can take it to investors, I can pitch it to vendors. And end of 12 months, I will have a better idea what my invention is, and then I can file the claims. Then it becomes complete specification. Yes? Okay. Drawings can be drawn with ordinary pen or computer-based art sheet. What are the forms that to be filed? I think you reach out to Prashant for the forms. I think Prashant's email ID is also available, or to Professor Dubey. One of them will be able to help you with the forms and so on. Drawings can be done by black pen, as long as it is clear, as long as there is no smudging, as long as it is neat. So it doesn't matter. In fact, in the US and in some of the more developed patent economies, they have patent illustrators. And these patent illustrators, they own the copyright to the drawing which they make on your patent. Patent may belong to you, illustration belongs to them. So they have very specific domains. So they may be very, very good in drawing body parts. They may be very good in drawing mechanical parts. They may be very good in drawing specific components of windmills or aircraft and so on. So you decide which illustrator suits you and you can go to them. They will use pens, they will use computers, they will use other devices as well. Classified information is not necessarily of IPR category. Classified information, so by classified information, if you mean information relating to military or other requirements, yes, it cannot be released as an IPR document. When
Weapons and arsenals.
Yes.
Weapons and arsenals. Weapons.
I'm not understanding, sir. So if it is a security related device, then when it comes up for examination, the government will classify it and it will be put under a secrecy directive. If the government decides that it is secret, then the government will not allow it to be granted as a patent. Otherwise, the government will go through it and say, okay, it is not secret, it is not a violation of security, or there is no danger from it of security or other proportions, then the patent will get granted. I think that is what you mean. Yes.
Yeah,
Yes.
I think, madam, you have covered all the questions, it
Excellent,
seems.
sir.
Yeah.
Yes, sir.
So, any question now in the chat box? Yeah, I think everything is fine.
Yes,
And dear
sir.
participants, if you have any question or any query, please email me and I will get back through, madam. Okay. So, madam, I have one question.
Yes, sir, please.
Which is very common question actually. I think this question must be having all the participants also.
Okay, sir.
How much time it takes to file a patent starting from the Indian patent to the US patent? Very simple question.
To file a patent or grant a patent, sir?
Granting, of course. Up to
Granting.
grant.
Okay.
Yeah.
Okay. See, if you start seriously researching on a patent, it takes about 3 years, 3 weeks to draft a patent, a proper patent along with all the documents. It will take you about 3 weeks to draft a good patent. Once you have filed it, you get 12 months. In these 12 months, you can go to any country within, okay. So we have to start again from 0 months because of the provisional application question. I want to start there. Let us say on this day, 0 period, 0 day, we file the application. From this day to 12 months, we have time under one treaty, under the Paris Convention Treaty, to go to different countries. So you can go to any of the countries within 12 months. If you don't want to decide to go in these 12 months, you want more time, then within 12 months, you can file an application in the World Intellectual Property Office, WIPO office. And the Indian office is a receiving office. So if you file it in the Indian office, they will transmit it to the WIPO. From then you have 30 months. So from here, now you have 2.5 years to go to different countries. Now, once you go to different countries, each country has its own process. In our experience, and this is only my experience, in India, it takes anywhere between 2 years and 6 years to grant a patent, depending on the domain. So it's biotechnology, new technology, which is coming in the computer science area, and so on. You can get it in about 1.5, 2 years. If it is mechanical engineering or chemistry, it takes longer because there is a backlog. So there are more applications in front, and therefore the examination takes longer, which is still better because when I started to practice, it used to take 8 years to get a patent. So now it is much better. The same application, after 12 months, I file it in the US, I can get most of the new technologies, biotechnology, computer science, instrumentation, robotics, autotronics, bionics, all of these nanotechnology, solar technology, all of these I can get within 1 year. So most of these new technologies within 1 year, chemistry and so on within 3 years. See, this is because and pharmaceuticals 3 years. This is because they have a process by which their patent office guarantees a grant within 3 years. So it depends on how rigorous the process is and how much the backlog is. I think 3 to 4 years is average for most countries that do a complete investigation. There are some countries like Singapore and Hong Kong where they have a process. If you get a US patent, UK patent, for instance, if you get a UK patent, you can file a patent in Singapore and they will not do a complete study. They will only do a technical study. They will only see that your basic criteria are met and they will grant it. So that will take very less time, 6 to 8 months, you will get a patent. There are about 25, 30 countries in Africa where they don't do any examination. So again, they only look at the regular requirements. Are you fulfilling the form, fees, all those aspects and very basic criteria are fulfilled, you will get. So you can actually get, in about 6 months, you can get about 15 patents. But those are very, provided that the technology is useful in Africa, it is a very useful idea. I remember for one of our companies who was working in the area of mobile telephony and generally transfer of money by mobile phones. So they wanted only patents in Africa, which was a very exciting opportunity for us to understand that market. So in fact, we got 27 patents from Zimbabwe, Tanganyika, South Africa, Sierra Leone, like that. We got around 27 patents in about 7-8 months. So it all, again, in Europe, it takes a little longer than the US. It takes, it takes about 4 to 5 years. There are 5 countries who have come together. So Europe, USA, China, Korea, and Japan. So these countries are trying to harmonize. They are trying to see if one country grants can be all grant. If something like that happens, then it will become very good for us. It will become more expensive, but it will become very useful because then we don't have to go to each country. So if I would say that if you're an inventor who's looking for investment and you're trying to schedule your timing, I would say be prepared to enter the market in about 4 years with about 3 or 4 different countries. Australia takes 2 to 3 years to grant some in some technologies. There also agriculture, pharmacology, and so on take longer. But IT and other ICT takes a shorter time. So in about 4.5 years, you should be prepared to go to the market with your technologies.
So is there, madam, any provision in India we can go for fast patent filing and getting granted?
There is a fast track process by which certain processes can be speeded up. So the examination can be speeded up and the publication can be speeded up. Generally, the publication of the patent happens in 18 months, but you can have a fast track publication in 9 months. And you can also put it on a fast track queue for examination. But the problem with that is the technologies where there is a large backlog, even those queues are filled up. So instead of 4 years, you might get it in about 3 years. You can't jump the queue to such an extent that you can get it in 1 year or so.
I see.
Yes.
Thank you.
But it's industry standard, so you should not worry too much. As soon as your application is there in the market, you're free to start using the technology, putting the technology in the market and so on. So that is one of the advantages. So since the protection date starts from the date of filing, you don't have to wait for the grant. You can actually start doing your work. It is only when you are trying to assign the patent or do some transactions with it, then the question of grant and other things become important.
Thank you.
Sure.
Thank you. So you have given answer of all the questions with the same energy what you have started. So thank you very much.
I'm getting used to it, I think.
And I'm getting a lot of comments actually from the participants, like amazing, excellent.
Okay.
It was really very good contents. You have started from the trading, then copyright and included patents. So very nice presentation, madam. Thank you.
Thank you.
Dear participants, thank you for joining us and thank you for your cooperation. This is time for the vote of thanks. So we are very thankful to, first of all, our today's speaker, Mrs. Swapna Sundar, for sharing her knowledge, in fact, enriched knowledge in the particular domain. And this is really very good knowledge you have shared, madam. And as per my knowledge also, when we compare our country with the foreign countries, we are really back for filing the patents.
Yes.
So somewhere actually this gives boost to start by our academicians to go further for patents.
Good.
So thank you very much.
Most
Thank you
welcome.
so much.
Thank you. Thank you.
We are thankful to our college management, Dr. S. Ramesh Babu, Secretary and Correspondent, for encouraging us and for the conducting of this kind of events, and our Vice Chairman, Mr. Kirti Kumar Garu, who also encourages us to continue this kind of events. We are also very thankful to our Principal, Dr. S. Suresh Kumar, who is our motivator. So thank you, sir. At last but not least, I'm very thankful to my team, Dr. S. Sarvanan, Mr. Venkatesh Epuri, Mr. S. Srilali, and Mr. D. Shekhar. So thank you very much. Dear participants, we are going to share you the feedback links via Telegram, WhatsApp, and email. Please fill the form and submit it. Within the 2 hours, you please submit your form and get your certificate. If you have any question, please don't hesitate to mail me. I will get it back to you. So thank you very much. So I declare here that today's session is over. Thank you very much, madam.
Thank you very much. It was a good session. Thank you.
Thank you. Thank you. Thank you all.